Good morning.
May it please the court, my name is Brandon Perkins. I represent the appellant, Wyndham. I'd like to reserve 5 minutes for rebuttal.
Okay.
Essentially, there's 3 issues that we're bringing to the court for its consideration. This was a trial. At the end of the trial, the judge awarded a judgment in favor of the appellees, Mask, and as well as TW, Taylor Woodrow. The first issue we'd like to bring to the court's attention is a contract interpretation. Essentially, at the heart of this case was a post-closing cooperation and services agreement, and the issue was whether that agreement was assigned. The agreement itself says that any purported assignment without written consent is null and void, deemed null and void. So,
but who are the only parties that can enforce that?
Well, if
can you as a third party enforce that? Is there any case law in Florida where a third party can enforce an anti-assignment provision?
No.
Between 2 other parties?
No, Your Honor.
Then how in the world can you enforce it?
Well, if it's null and void, it didn't happen, and they can't waive it.
Well, who declares it null and void? One of the parties?
Well, I believe
it would either have to be EarthMark or Taylor Woodrow. Did they ever do that? Did they ever declare it null and void?
No. If you look at, though, the contract between Wyndham and Taylor Woodrow, they accept assignment to the extent assignable. And so, therefore, unless it's assignable, which would require written consent, then we would not have an assignment of that agreement.
Well, there were 2 ways to assign. One was with consent, or the other way was by transfer of all or substantially all assets, correct?
Correct. And if you read that provision in its entirety, if you transfer substantially all the assets, it talks about the ways that that could be done: merger, acquisition. What it's talking.
Sale.
What? Sale. Stock transfer.
Sale.
Right.
Sale to Herb Lawson.
And agreed. The agreement talks about how that would be done. The sale of the assets would be one of them, but if you read it, what they're getting at is successor liability. If you transfer substantially all the assets, what you've done is you've created a successor liability, and the predecessor corporation, in this case TW, its business would fundamentally change. Therefore, ultimately the successor would have liability. That's the way I interpret this agreement. The trial judge disagreed with that interpretation. Nonetheless, the way I read it is, if there is a sale of assets, substantially all assets, that creates successor liability, then you wouldn't need consent. The second issue I would like to address with the court is the trial judge considered a deposition transcript that was not introduced into evidence at trial. The trial judge in the judgment quoted from this deposition transcript, and you can see that what the trial judge did is juxtapose the testimony at trial with what would, I guess, the trial court felt was inconsistent testimony at the deposition. If you look at the recent case of Special versus West Boca Medical Center, it was issued by the Florida Supreme Court this past November. It changed the harmless error analysis for civil appeals. Both Mask and TW argue harmless error for this quoting and reliance upon facts outside of evidence. The new standard is, as quoted by the Supreme Court, to test for harmless error, the beneficiary of the error has the burden to prove that the error complained of did not contribute to the verdict. Alternatively stated, the beneficiary of the error must prove that there is no reasonable possibility that the error contributed to the verdict. So here we have a situation where the judge quoted from a deposition outside of evidence in reliance upon findings, and therefore clearly, on the face, it contributed to the decision of the judge, and we would ask that you reverse on that basis as well. I will take the balance of my 5 minutes for rebuttal.
Thank you, Mr. Perkins. May it please the court, the time is going to be split up evenly between myself and Counselor Sliver. I think that in order to give context to the presumption of correctness that should be given to the final judgment entered by Judge Lobato in this case after a 2-day non-jury trial, a brief statement of the facts would be in order. And in particular, I would note that there isn't a single fact in the record that was part of the trial transcript that was refuted by the appellant in their briefs or during their initial argument today. So very briefly, Your Honors, Coolidge Fort Myers Realty Partnership owned a master plan community known as Heron's Glen. And in 2005, Coolidge sold Heron's Glen to Taylor Woodrow. Water and sewer capacity was what was critical, because in a planned community like this, if you don't have it, you can't build on it. So it was one of the most important things that any developer looks to when it buys a subdivision. That was certainly true of Taylor Woodrow. So to assure that they had sufficient capacity, they entered into, between Coolidge, Taylor Woodrow, and an affiliate of Coolidge, EarthMark, entered into what is called as a post-closing cooperation and service agreement. I'll refer to that as the post-closing agreement during this argument. Now, in that document, which is the essential document at issue in this case, Section 1.4 of that post-closing agreement provided an obligation for EarthMark to pay $1.2 million to the utility, and they did so. And as a result of that, they received the capacity of 1,900 residential units that could be built in that community. And in exchange for that, under Section 1.5 of the post-closing agreement, EarthMark would in return receive $3,380 for each time that an application for a building permit was sought. That was the way in which they were going to recoup their investment of the $1.2 million. Now, in December of 2008, there was a purchase agreement entered into between Taylor Woodrow and Wyndham. Now, Herb Lawson, the principal of Wyndham, was a sophisticated developer. He had done over $1 billion of real estate in his 47 years of development. He participated in the due diligence process, and in the purchase agreement, he agreed that he would assume and take assignment of all contracts, including this very contract, the post-closing agreement. In paragraph 7 of the purchase agreement, he assumed the obligations of Taylor Woodrow under all the contracts, including this contract. He initialed the page of the purchase agreement, which disclosed the post-closing agreement. He visited the community, he met with representatives of Taylor Woodrow, and in particular, in the trial testimony, the principal, one of the principals in Taylor Woodrow, representative, provided Lawson with a copy of the purchase post-closing agreement and discussed the payment obligations thereunder. So Taylor Woodrow's representatives testified that they believed Lawson understood what he was explaining, what he was essentially agreeing to. It's also undisputed in the record, Wyndham failed to inventory the contracts, did not request any more documents, had no understanding, and did not make any effort to determine which of the contracts they were taking assignment of.
Didn't they ask for 10 days closing instead of the 90 days that Mr. Lawson usually required?
He may have asked for additional time, but he ultimately, at the end of the day, decided to close the transaction.
Well, actually, he testified that it usually takes 90 days to close on these deals, but he agreed to close in 10.
That's exactly right. So he chose to close on this transaction with a short due diligence period because Taylor Woodrow wanted to close by the end of the year. He had legal counsel consulting with him throughout the transaction, and even though legal counsel in that capacity was suggesting that perhaps more time would be helpful to him, Mr. Lawson made the decision, because he thought this was a good opportunity, to close under a very short due diligence period. But what there's no dispute about in the record is he got the purchase agreement, Judge Sleet. He understood he was taking assignment and assumption of all of these contracts. And he chose to close, understanding that he had an obligation. And even after he became aware of what the obligation was, so he says, he never sought to rescind the agreement. He never sought to set it aside. He took all the benefits of the transaction, but he didn't want to accept any of the burdens or obligations. to have his cake and eat it. And as a sophisticated developer with 47 years of experience doing $1 billion of transactions, that's not the way it works. When you buy into a transaction like this, you accept the rights and the obligations. So, Your Honor, what then happened in the case is a summary judgment was entered against Taylor Woodrow. They were found to be liable as a matter of law. No appeal was taken of that verdict, and it was determined that there was no novation. There was no assignment which relieved Taylor Woodrow of the obligations. So when we come to this court here today, what are the defenses that are even raised by Wyndham to the judgment that was entered by the court against them and in favor of our client? So when you look at the actual issues before this court, we pointed out in our briefs that the whole issue of the deposition transcript, that specifically was raised only as to the fraud and negligent misrepresentation defense that Wyndham alleged against Taylor, not against our client. So while we don't believe it was harmless error, and I'm certainly prepared to argue that it was not harmless error for a variety of reasons of evidence that was in the record.
You do or you don't believe it's harmless?
I don't believe it was harmless error because I don't think there's any reasonable possibility the court could have reached a different conclusion. So applying the case that the Boca Medical that just came out, which I think just clarifies the harmless error rule in a civil context, I don't think that the result should be any different. All the evidence in the record, and I thought it was very interesting when you look at the judge's decision on page 17, she says, and this is just from the trial testimony, there is no evidence that Wyndham relied on the information in Schedule 3A. Mr. Lawson provided testimony at trial that he did not inventory the contracts Taylor Woodrow provided to Wyndham and did not undertake any effort to determine which were assignable. Mr. Lawson testified at trial that he recalled looking at the Schedule 3A and specifically the post-closing and services agreement, but that he did not spend any time looking into it. Your Honors, the deposition testimony, it was cumulative. It was essentially a mirror image of much of what was testified at trial. What I have not seen presented in the brief of the appellant, nor presented in oral argument, is where is the evidence of fraud? Where is there any evidence of fraud? To the contrary, the overwhelming evidence in the record, certainly more than even substantial competent evidence in the record, is that there was no reliance on Schedule 3A. No reliance, no fraud. There's not even proof of any type of fraud. But counsel for Taylor Woodrow, I'm sure, will address that issue because, again, that particular issue isn't even raised as a defense, fraud, against our client. So it can't be a basis to set aside the judgment. And that testimony, that deposition testimony, which is essentially 2 pages out of an entire transcript that was several hundreds of pages, does not address any other defense relating to our client. So with that, I'm going to move on to the second argument, which I think is a critical argument to us because I don't know where the law has changed on novations and assignments, but it certainly has not changed before this court or any other court in the state of Florida. The law is very simple. You can assign a contract, and the person who takes that assignment accepts the rights and the obligations by that assignment. And that was clear in this record by looking at the purchase and sale agreement. That's what Wyndham agreed, to assume all the rights and obligations, the benefits with the burden. What is clear from this record is that there was no novation because our client never agreed to release Taylor Woodrow. And that's what the court found on summary judgment against Taylor Woodrow and entered summary judgment, and that became the law of the case. So the law is clear, and even in fact we cited to several cases, both the Mooring case, we cited to even Hornbook Law, Williston on contracts. A valid assignment can occur without a novation that would release the original obligor. That's the law. So the law that's being thrown at this court, it doesn't exist. There is no such thing that you can accept just the rights and somehow release the original obligor unless the parties to that original contract intended to release that obligor. That's the whole issue that's raised in the mooring case that we cited to the court.
Excuse me, if you want to split your time evenly, you're at 10 minutes.
Okay, I'm just going to take one more minute just to point out one other issue for the court. So, Your Honor, we would argue, as presented in our brief, that the other issue that was presented was the issue of whether there could be an assignment. And I think, Judge Sleet, you addressed that issue right on point. Wyndham has absolutely no standing, no basis to raise that issue because it is the non-assigning party that has the right to raise that defense. The only party who has the right is our client and not Wyndham. As far as the substantially all argument and the successor liability, I will leave that argument to Taylor Woodrow, and we ask that your honors affirm the final judgment entered by Judge Laboda. It is presumed to be correct, and it was in fact. So, thank you very much.
Thank you, sir. Got about 9 minutes.
Okay.
Okay.
Good morning, everybody. First of all, I think my colleague, Mr. Pardo, misspoke. I think what he meant to say to Judge Steele was it was harmless error, and I think he misspoke and said it wasn't harmless error. So I think that was obvious, but I just wanted to say
Understood.
that. First of all, let me address the three issues very briefly. The first issue is the contract assignment, and we win that three ways. As Judge Steele presents, that can only be raised by Mask. Can't be raised by an assignee as a defense. Secondly, the court found in the record, based on ample testimony, that Mask in fact consented by virtue of the fact that they started billing Wyndham. They didn't object, and they even talked to the principal of Wyndham about this, and Wyndham used the credits, or their builders used the credits, these sewer credits. So by operation of the parties, consent was given, although not in writing, and that's in the judgment. The third way we win is that substantially all the assets of the property were sold.
Is a test on that, as Mr. Perkins says, it's a successor liability?
Absolutely not. That's not what the contract says.
All right.
My learned colleague is confused. He's picking up cases where you have corporate merger that talk about stock sales, you know, like this Falstaff case that they cite, which is a 50-year-old Texas case. That's not what this contract says. It says the sale of substantially all the assets in the community. And the undisputed evidence was all the common areas were sold, the golf course, the swimming pool, the clubhouse, plus 95% of the lots in the community were sold. That's substantially all, according to the trial court's ruling, based upon conflicting expert testimony. So I think on any of these issues for the contract assignment, I should never say this, but it seems like it's a slam dunk. Now, let me deal briefly with this deposition testimony. There were 2 pages of a 22-page opinion that incorrectly cited a deposition transcript and shouldn't have. It was listed as a pretrial exhibit and was just not introduced. It was our fault. It has nothing, it's not, this was harmless error by definition. It is undisputed that my client testified that he sat down with the principal for Wyndham, showed him this contract, talked to him about the obligations of this contract. That is certainly substantial competent evidence, and it only makes sense that that happened. No experienced developer, which is what Wyndham was, would buy an undeveloped subdivision without knowing whether there were utility hookups or not. And as a matter of fact, the undisputed evidence is once there was negotiation between these two parties, all they did was say, we want to reduce the amount we pay. They never said, oh, geez, we've been defrauded, we're going to cancel this, you know, we don't want anything to do with this contract. That wasn't the response at all. There was never an assertion of fraud until they were sued in this lawsuit. Now let me talk very briefly about the crux of the trial court's finding. The crux of the trial court's finding is, wait a minute, Wyndham, you cannot use these utility hookups, get a financial credit for what his client paid to get these hookups, and then say the assignment is void ab initio. It makes no sense. Either it was assigned or it wasn't. If it was void ab initio and it wasn't assigned, then they have no utility credits, and they can't use these utilities. There was no partial assignment. There's nothing in any of these documents saying we're assigning you the benefits but not the obligations. Exactly the opposite is true. There was an assignment and assumption agreement between Wyndham and my client that said every contract that was assignable was assumed, and they indemnified us. That's why we got a judgment against them. So if it was assignable, they've indemnified us. If it was not assignable, then they can't use the utility hookups and the credits, period. You can't have it both ways. That's what the trial court found. Very briefly, there's one argument that was in their brief that they didn't address on oral argument. This is the judicial estoppel argument. It's very clear that both an assignor, my client, and the assignee, Wyndham, can both be responsible for the same obligation. Let me give you an example. Let's assume that this is a commercial lease and my client is the tenant. And there's a landlord out there and the lease says it's not assignable without written consent. But yet a new tenant moves in and everybody agrees, but there's no formal written consent given. My client goes out of business or files bankruptcy. This, by the way, is what happened in 2 of the cases in the briefs. Can the tenant then argue with a straight face they don't have to pay rent for the next 20 years? Because you only assigned the benefits but not the obligations under the contract. Well, that's ridiculous. And that's exactly the crux of the trial court's ruling. You can't have your cake and eat it too. There was certainly substantial competent evidence from Mr. Lawson at trial. As was mentioned, never inventoried the contract. He testified, this is hard to believe, that he never even investigated the utilities when he bought the subdivision. And his lawyer said essentially the same thing. Judge Sleet said, well, geez, you know, he only had 10 days to close. That's true. He paid nothing for the subdivision other than assuming these contracts. That's why my client needed to close before year end to get the tax write-offs or whatever happens when a developer sells a subdivision. And he knew that. He was a very experienced developer with a very experienced lawyer. If he had wanted more time, he would have negotiated it. And certainly if he didn't have enough time to close, under the contract he could have rescinded it and not closed. There was, again, never any complaint about fraud until after he was sued in this lawsuit. So for those reasons, the contract was assigned, there was consent given, the reference of the trial court to the deposition testimony was harmless error, and with regard to the judicial estoppel, there is nothing inconsistent with finding both the assignor and the assignee liable, and we've cited ample cases, including the Mooring case and the Hargerdin case, which hopefully I'm pronouncing that correct. And again, all the Supreme Court case, new Supreme Court case does is shift the burden to us to show that it's harmless error. We've done that, and we believe that the trial court's ruling should be affirmed. Thank you.
Thank you. Mr. Perkins, here.
Yes, Your Honor.
5 minutes of
The
rebuttal.
final judgment starts off and says that the court listened to the testimony, the evidence at trial, and the evidence in the court file. It goes on to quote extensively from the deposition of Herb
Court
Lawson.
file, doesn't that mean exhibits admitted into evidence? That's in the court file.
It certainly could mean that, but given the fact that the trial judge quoted from evidence that wasn't, or quoted from documents not admitted into evidence, means that we don't know. And
we have 6 pages where the judge details the trial testimony, and we have a page and a half of a deposition reference. So we're to conclude that this page and a half deposition reference permeates the entire order.
well,
That it significantly affected the court's decision.
I think the Supreme Court's ruling says, is there any reasonable probability? And if there's not a reasonable probability that it affected the court's decision, then obviously the harmless error analysis would apply. But if there's...
Tell me in the record where Mr. Lawson testified differently than what's cited here.
My reading of the record and what the trial court did was the trial court set up Mr. Lawson's testimony at trial and then impeached it with his deposition testimony.
Oh, I think he was impeached quite a bit.
Well, and I think that what the trial court did by using the deposition testimony instead of just the evidence at trial is where we have a reasonable possibility that the non-evidence affected the judgment.
Well, see, the deposition citations are within the fraudulent misrepresentation, entitled fraudulent misrepresentation. So we
Correct.
can conclude that the deposition transcripts cited there were used in reference to that, correct?
Correct.
But if you look at his testimony was, I was never given that contract. I never would have closed without dealing with it. Then he goes and clarifies, well, I was given a box of stuff, but I didn't have time to read it. I did initial that contract, I just don't remember it. And then his lawyer shows up to trial, and he also has a breakfast with his lawyer and tells his lawyer his opinion about the testimony of the other witnesses, which incenses the judge. And the judge finds out about it, just about ready to hold him in contempt. So now aren't we dealing with a situation where the trial court's decision regarding Mr. Lawson's credibility, we should give deference to the court?
Well, I think that if there's no reasonable probability that the deposition transcript affected the judgment, then the harmless error analysis would apply. I think that if there's a reasonable probability, then I think...
No, that's why I'm asking, in the record, can you show me where he did not testify to the same thing that's found within those deposition citations?
I go back to my statement, Judge. I believe that the deposition testimony was used to impeach his trial court testimony by the judge. I believe that was improper. I understand exactly where you're coming from, Judge, not disputing what you're saying.
But Mr. Lawson's depo was used to impeach a couple of witnesses, including Mr. Paulzlak, whoever he hired. And when Mr. Paulzlak was presented with Mr. Lawson's deposition testimony, where Mr. Lawson said, I disagreed that I owned the payments under the PCCSA, Mr. Paulzlak said, well, Mr. Lawson never said that. So it was used. I agree it wasn't admitted, but it was used a couple of times. I'm just still trying to find how this is error and how the cumulative effect of the evidence doesn't show that this is harmless.
Well, all I can do is go back and say I don't believe the appellee proved that there was no reasonable probability. Obviously, you can disagree with me on that. I understand where you're coming from, you know. So we would ask that you reverse the trial court's judgment. Thank you for your time.
Thank you. That concludes our docket for this morning, and we are adjourned.